All right. Good day, Your Honor. As you said earlier, today we're here for a hearing on defendant's motion for leave to designate third parties. Before we get into the substance of this motion, we first need to address Texas law very briefly on designating responsible third parties, and specifically how a defendant is supposed to object towards designating these third parties.
A defendant or a plaintiff?
What's that? The plaintiff is supposed to object. I'm sorry, Your Honor.
That's okay. I just want to make sure I was following you.
We filed this motion 161 days before the trial date, which is scheduled for February. It says February 16th, 2001. So we did this 161 days before trial. And I would just like to read three cases, one Texas Supreme Court case and two Dallas Court of Appeals cases that specifically talks about designating third parties and what the plaintiffs are required to do. And these are three cases in which the trial court unfortunately was mandamus for not allowing the parties to be designated the responsible third parties. And it goes into what a plaintiff needs to do in order to stop it. And each one of these cases is really just talking about the Civil Remedies Code, number 33. And that's what we're talking about, is proportionate responsibility. And so without further ado, I would like to read into the court the Texas Supreme Court case of In Regard Frank Coppola. And this, like I said, is the Supreme Court of Texas, and it is 535 Southwest 3rd Edition, 506, Texas 2017. And one of these cases is saying is what's supposed to happen. And it says, subject to certain limitations, not at issue here, the Texas Civil Practice and Remedy Code permits a tort defendant to designate a person as a responsible third party by filing a motion on or before the 60th day before trial date, unless the court finds good cause to allow the motion to be filed later. The trial court shall grant leave to designate a responsible third party unless another party objects within 15 days after service. And they did object. They didn't object correctly. And here's what is allowed. Even with a timely filed objection, the court must allow the designation unless the objecting party establishes the defendant did not plead sufficient facts concerning the person's alleged responsibility, sufficient facts, and two, the pleading defect persists after an opportunity to replead. And this court, and then it goes into why mandamus relief is appropriate. Now I'm going to have another Court of Appeals Dallas case that actually goes into exactly what a plaintiff needs to do. And this case is In Regard Greyhound Lines Incorporated, it's a 2014 WL 1022329. And it says, it talks about how the pleading requirements for designated responsible third party are not stringent. It goes under the Texas standards of fair notice pleading, and it goes through all of that. And the trial court, it says, is restricted to evaluating the sufficiency of the facts pleaded and is not permitted to engage in analysis of truth of the allegations or consider evidence. And the last case that I'm going to read in is another Dallas Court of Appeals case. And this is In Regard Houston and Smith. And this is 366 Southwest 3rd Edition, 282 in Dallas 2012. And this says, as the party opposing a motion for leave to designate a responsible third party, plaintiff bore the burden of establishing two elements: that defendants did not plead sufficient facts concerning the responsible third party's responsibility to satisfy the general pleading requirements of the rules of civil procedure, and that the defendants still failed to plead sufficient facts after having been granted leave to replead. So I would like to now go to what they did in their objection. And this is the objection, plaintiff's objection, that was filed on September 23rd. And plaintiff says that, this is all they say: plaintiff objects to defendant's motion as unsupported by any evidence and respectfully requests a hearing. That is not a proper objection for designating responsible third parties. This is not an evidentiary hearing. There's no evidence that needs to happen here. I think they're confusing the requirements for designating third parties with the actual motion to strike once they've been designated. That happens later after there's a certain amount of discovery into these claims occurs. So right off the bat, it doesn't seem like their opposition is really in accord with Texas law, Texas rules of civil procedure, and the remedies code right off the bat. And now that we've said that and we've outlined the law about what is required for a motion to designate third parties, I'd like to go into our motion, which actually far exceeds the sufficiency notice pleading that is required by Texas law. And if you look at it, we go into the background facts and we talk about what happened in this case, because we deposed Mr. Rowe, the plaintiff, and that's immediately after we deposed Mr. Rowe that we filed this motion to designate responsible third parties. And because we learned at the deposition that he basically was walking on the premises of this other company. It's called Bamboo Asian Market, owned by a Jenneth Binion. And while he was walking on their premises, he basically just slipped on a sloped curb. And the plaintiffs produced pictures of this curb. And Mr. Rowe stated that on this curb, there was this large crack that he stepped in. He also said that we had no knowledge, the defendant, Hanmi Food, his employer, had no knowledge of this crack or slope, or he didn't even know if we would. He said that he wasn't carrying anything heavy. He admitted to all the employers having no duties elements, so that he admitted that it was a commonly known hazard when stepping on curbs. He admitted that it was a routine job. He admitted that he wasn't carrying anything heavy. But what happened was he stepped on a large crack in a surface on someone else's premises and then hurt himself doing so. And so then we went into, and if you look at our motion, Your Honor, like I said, we went far beyond the pleading standard. It's almost a half motion for summary judgment concerning all the law and facts that we put into it. We talked about how he was in a premise liability case. Mr. Rowe was an invitee of Jenneth Binion and Bamboo Asian Market. We talked about how in a premise liability case, what duty is owed and what they would need to prove in order under these facts. You know, it was unreasonably dangerous and the premise liability knew about this large crack in this slope surface. And we went through the entire thing. He injured himself while delivering merchandise as an invitee of this property. So we've done more, beyond more than is required for designating motions for third parties. And they have the burden of objecting to this and didn't even object to it correctly. They said there's no evidence. That's not what we're dealing with here at all. This is sufficiency of pleading standard, and they have not objected properly. So, Your Honor, that's pretty much the whole thing. We're trying to designate Bamboo Asian Market, who owns the company who's on there. Jenneth Binion we did the CAD search and we attached that as evidence. She's the legal owner of the property. She's also the owner of she's the managing member of Bamboo Asian Market LLC. And she owns, into the property records of the CAD search, she owns the property underlying property. The only question in my mind is who owns that property? Is it the sloped sidewalk which has the large crack where he tripped? Is it the city of Wichita Falls, or is it Bamboo Asian Market, or the Jenneth Binion? And those are the things that we designated all those three parties to try to figure out. Is we know he slipped on this sidewalk. We think it's Bamboo Asian Market, but we're not exactly sure. That's where we're at right now. And so on that note, that's why we did our motion to designate responsible third parties for the premise liability claim of Bamboo Asian Market against Bamboo Asian Market, Jenneth Binion, and possibly the city of Wichita Falls, Texas. Wichita.
Response.
Thank you, Your Honor. Our response is simply that the defendant's not met the burden for designating the third party. Respectfully, in our petition, we've alleged negligence of a non-subscriber. We've not alleged premises liability. even past the mechanics of the injury, we allege that the actions of the defendant after the injury contributed to further injury and suffering of the plaintiff. And that's all.
All right. I'm going to go ahead and grant the motion for leave. I don't see that you provided an order for that. Did you guys provide an order?
I will file one right after this, Your Honor.
Go ahead and file it and e-file it, and then also email my court coordinator.
I will do that. Thank you, Your Honor.
All right. Anything else, guys?
Not from the
That's
plaintiff,
everything.
Your Honor.
Okay. All right. You guys be safe, and we'll try to get that signed as soon as we can.
All right.
Thank you,
Your Honor.
Thank
Have a
you,
great
guys.
day.
You too. Bye-bye.